Hey, this is Rodney Rouzan with War Wars 101. And one of the things I wanted to talk about this evening was about, litigation in general. And when somebody decides to go and be pro se, pro per, you call it pro se, and that's pretty much just a litigant who decides to represent oneself. And I even hear some people say, you're a fool if you represent oneself. And I don't agree with that completely. You're only a fool if you don't understand the rules and then you represent oneself. And pretty much like what I've always seen, it's just it's a language. It's a certain language that is being spoke. It's legalese, or it's also what I just consider procedural law. One of the things I see is people that don't understand like the litigation side, you can understand substantive law. That's just the law, basically what it says, you steal from me, that's theft. And pretty much that's the law, the way it's written. But then after you get past the substantive law and you maybe have an issue, now you have procedural law when it gets into a court of law. And there's a certain way, there's a certain language. It was really funny. I was watching this, I think he's out of Detroit, and it's this judge, his name is Cedric Simpson, on the internet. And then he had these individuals on there that were representing themselves. And the main thing that I saw was they didn't even understand how to do a motion. So when you're talking to the court, you have to do motions. And there's everything is brought in a certain way, certain procedure that everything has to be brought. So if you don't do that correctly, then you're lost in the water. If you're just talking to the judge, you have to realize a lot of what a judge does is already done by the law clerks, or whoever behind the scenes. So when you actually have a motion and you're there for the hearing that day, all the paperwork was already due multiple court days prior to that. So originally somebody will bring a motion and somebody has to bring an opposition, and then there's a reply, and there's certain timelines depending on which jurisdiction you're in. So that's keys that you have to understand. Where I learned and what helped me, the main thing that helped me understand this was there was a course called Jurisdictionary, and there was an attorney out of Florida. His name is Edward Graves, and he intentionally taught this because he was like, it's a really simple system, but you have to understand it. And if you don't understand the basics of it, you're like a fish out of water. You'll never understand it. A good example is, I saw the other day, I was at Panera Bread, and I saw individuals, they have a little chess club and they learn how to play chess. I've never been taught how to play chess, so I can't expect to go in the game and beat a chess player. See, because I don't even know the first move, second move, or there's counter moves and all these other things. And it's no different in court. When you bring your initial complaint, if you don't plead correctly and you don't plead the causes of action, they do a thing called a demur. In state court, it's called a demur. And then in federal court, it's called a 12B6 or motion to dismiss. So you have to understand first how to even bring your complaint. Then when the opposing counsel even brings the answer, did they even bring the answer correctly? Like if you have a verified complaint, did they bring a verified answer and confront all your different issues? Because their attorneys would try to slide that in. They'll slide in affirmative defenses in order for them to bring an affirmative defense, that's a defense that they may have to the allegations that's being made, but they have to plead facts to support those affirmative defenses. They just can't plead it, or you have to know to strike that out. And then even when you get into discovery, there's a game that goes back and forth with the attorneys as well. So these are just little nuances that you have to know. And Jurisdictionary was the best course that I saw. It was like he wrote the books, he put cartoon figures on it. He really made it easy to see. Like when you're doing your initial complaint, they call it framing the pleading. So he put a frame up there, show when you're pleading, and then what stays in and what can't come in from the other side, and which you have to block. So that's really important. Once you understand the language, the legalese, then you'll have a lot better opportunity to get good results. And you don't want to just get dismissed on a technicality. You want your case to be heard on the merits. And that's the whole key behind being a pro per litigant. You have to know the game so your stuff can get heard on the merits. So keep that in mind. Like I said, Jurisdictionary, you would have to, that's one of the keys if you want to act as a pro se litigant. So thank you. See you in the next video. Like and subscribe. Peace.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.